Good morning. We welcome everyone to our March session of the Supreme Court. Occasionally, when we were able to sit in the courtroom, to which we hope to return as expeditiously as possible, we would have groups stop by, students, high school students, college students, law school students. We have one special group that's been with us quite a number of years, and I would ask Justice Todd to mention them and welcome them to our session.
Thank you, Chief Justice. Indeed, we're always happy to have students join us here, normally in one of our courtrooms, but this year remotely. One particular group is from Elwood City. They are from the Lincoln High School, which is my alma mater in Elwood City. And this group is the senior class AP U.S. Government and Politics. And what is interesting about them is their teacher, Mr. David Gabus, has been taking the kids to one of our courtrooms for the spring session every year for 10 years. They started by going to Harrisburg, and then they started going to Philadelphia. And I believe the last 8 years they have been in Philadelphia. They make a field trip out of it and leave by train from Pittsburgh and arrive in Philadelphia, spend a day with us in our courtroom, and then tour some of the important areas of Philadelphia to learn more about Pennsylvania and the United States government. So we are always happy to see them, although we can't see them today. They can see us. I understand they are gathered in the high school library, and they are all watching this today. I hope there are some future lawyers there. In great part, Chief Justice, that will depend on the excellence of the arguments we hear today. So welcome, students.
Thank you. We welcome you. We'll call now first case, right?
This is in the matter of Donald B. Moreman. Representing himself is Mr. Donald B. Moreman. Representing the Office of Disciplinary Counsel is Mr. Samuel F. Napoli.
This case involves the disciplinary regime for lawyers. The attorney involved, Mr. Moreman, pled guilty to crimes of forgery and theft. And the disciplinary board of our Supreme Court has recommended his disbarment. The court this morning is entertaining oral argument per Mr. Moreman's request. Mr. Moreman, would you proceed?
May it please the court. What we're here today to look at is, in my opinion, what is a best interest plea in the criminal justice system, which I've represented, I've argued, and I presented testimony that is what I did. I was a member of a Pennsylvania Freemasons Association where I was charged with two others with signing checks and paying bills. We had a practice of signing checks in blank, which would be affixing our signatures without the check being filled in. It was a standard practice that we had used for many years. Every other Masons Lodge that I had attended, many throughout the state, used similar practices. However, in this case, one of the other signers indicated that he did not, in fact, sign the checks. We would meet at least twice a month, sometimes more, typically throughout the year. In the summer months, the lodges would be dark, which means there would be no meetings held, and we would meet at least once a month to sign checks to pay the regular and ordinary bills. That's what we did. During the time frame in question, none of the bills were left unpaid. However, during that same time frame, one of the other signatories was an administrator of an estate for his aunt. Unfortunately, he did not identify other heirs in the estate. When that came to light, a hearing was held before the Court of Complex of Fayette County, and that other signatory was held accountable. He, of course, held me accountable, and he came forward and said he was not signing the checks which were used. I could not prove any difference, so in talking with the attorney who I had for the matter, through the district attorney as well, it was agreed for me to enter a best interest plea and not face any potential jail time. That was my paramount concern at that time. During the disciplinary process, I explained that to the committee, to the board, and fortunately, no one grasped that concept. It was only, there was a plea, because the plea was entered, something was done wrong. There was no consideration given for the fact.
Mr. Moreman, it's Justice Fair. I think that's absolutely correct. I think the horse has left the barn. You pleaded guilty. You can't plead guilty in America, in the United States, if you don't say on the record that the reason you're pleading guilty is you did it. Once you do that, I don't think you can argue in the alternative in subsequent proceedings. And indeed, we have a rule of disciplinary enforcement, I'm sure you're well aware of, 214E. It says the guilty plea is conclusive. So respectfully, I think, at least for me, you're wasting your breath. You pleaded guilty. For our purposes, you did it. If you didn't do it, perhaps we should remand. I don't know that we can do this. I don't know the niceties of the jurisdiction. Have you withdraw your guilty plea and go to trial and prove your case?
That's not where I'm headed from. Valentino, which states that the circumstances surrounding the plea are important for this process, for the disciplinary process. And that's what the board failed to follow. The board took the approach that you just voiced. There was no other thing necessary other than your guilty plea. Case law, Valentino specifically said that's not the case. We look at the facts surrounding. That's what I'm trying to do.
Anything else, Mr. Moreman?
I have one question. Counsel, just for the record, are you admitting that you stole from your lodge?
In my best interest to admit so, yes.
No, that's not the question I asked for you. Because candidly, I'm going to ask you one more time. Otherwise, it seems like what you're trying to do is share with us that you pled guilty for your best interest, but you didn't commit the crime, so that as an attorney, you are abusing the rule of law. So I'll ask you one more time. Did you steal from your Masonic lodge? Yes or no?
Yes.
Okay.
And the reason why I say yes, sir, is because I did use the checks in blank, which were not specifically authorized. I did that based upon prior practice. I should not have. That is my crime, yes.
Did you spend it on your personal welfare?
I did not, sir. As I provided proof to the board, I had bills paid through the association regularly, timely, and with the checks in blank, sometimes with my personal credit cards that I paid the checks in blank when we would go to Sam's Club or some other place where the supplies we would need, cleaning supplies and whatnot, would be less expensive.
So the last question I'm going to ask, so are you sharing with us today that at no time with the money that you're alleged to have stolen, did you use it for your personal use in any form or fashion?
That's correct, I did not.
Okay. I have nothing further.
Thank you, sir.
Mr. Moreman, you had the opportunity, we granted to say what you'd like, and you've described the circumstances of your guilty plea. Do you have anything else to offer in mitigation, counter the recommendation of the board for disbarment?
Yes, sir. That would be that I've had a 32-year career without any criminal nor disciplinary issues. I've been an active member in my community since this has come to light, and I have acknowledged my responsibility, taken criminal responsibility and professional responsibility. I have many, many clients who have asked when I would be available to represent them again, to which I've had to respond, I may not until I'm so authorized. I have completed everything under the criminal sanctions which are imposed upon me. I'm no longer on intermediate house arrest. I'm simply repaying the fines at a monthly rate. I'm waiting for my life to continue. And requesting that this board, that this body consider that, and that I have in fact taken responsibility. I cannot see where else I can make any other act of contrition to make it so. Thank you.
Well, if you have final question, and then we'll hear from the disciplinary council unless some other justices have questions. What are you repaying the money for if you didn't use it for your personal use? You're gratuitously paying money that you never.
Sir,
that's nonsensical.
Okay. At that time, sir, my attorney and I were negotiating with the lodges to repay everything they claimed was gone in order to have everything no prost and there be no criminal charges. Unfortunately, our district attorney—
You didn't take the money. What are you paying it back for? You said you didn't take any money. You didn't use any of this money illegally.
To avoid this process, number one, and the criminal process, number two.
Okay, thank you.
Thank you, sir.
Disciplinary counsel, Mr. Napoli.
Thank you, Chief Justice Saylor. Honorable Chief Justice and Justices of the Supreme Court of Pennsylvania, I am Samuel F. Napoli, representing the Office of Disciplinary Counsel. First of all, you have before you the question of whether Donald Blake Moreman should be disbarred, as recommended unanimously by both the Disciplinary Board and the Hearing Committee, which originally heard this case. It is our position, as it was of the Disciplinary Board and the Hearing Committee, that any lawyer who over a period of 14 months commits 83 felonies, stealing almost $50,000, should be disbarred. Mr. Moreman has not presented anything which would mitigate his misconduct. When he states that he has the absence of a disciplinary history, this is something which is simply expected of lawyers. That might be the absence of an aggravating circumstance of a prior disciplinary history, but it is not mitigation. Second of all—
Napoli,
yes.
You have before you the record. You're familiar with it. We have the briefs. Did you hear Mr. Moreman's presentation to the court?
Yes, I did.
Do you believe that it was honest and forthcoming?
No. Mr. Moreman, first of all, enters a plea of guilty, and as it's reflected in the transcript of his guilty plea, he says he's pleading guilty because he is guilty, because he committed the crimes of which he was accused.
Well, separate apart from that, he claimed in response to a question by Justice Doherty that he used none of this money for his personal benefit. Is that accurate?
That cannot be accurate. That is contrary to his guilty plea. And Mr. Moreman, the only evidence of that was Mr. Moreman's own testimony, which, in our opinion, was over our objection during the disciplinary hearing. The issue of whether he is guilty or whether he stole money, whether he used it for his own purposes, is over with. Under the rules of disciplinary enforcement, the only reason we're here today is to determine the degree of discipline to be imposed for his admitted theft. What he is trying to do by saying the money was not used for his own purposes is to revisit the question of whether he committed the crimes. He just cannot do that under our rules. And Valentino simply does not mean—
Yeah, as Justice Bear said, do it on any rules because his guilt is a legal fact. It was established by his plea, so we can't listen to any of that.
Exactly. He has admitted stealing almost $50,000. He made restitution under pressure at the time of the criminal charges which had been filed against him. He did not make the restitution until the time of his preliminary hearing.
Counsel, could I follow up on the theft?
Yes.
Does it, in your view, should it make a difference to us? And you know, please advise if the cases tell us anything in this regard, that the convictions did not involve client funds. In other words, does that matter? Here it's the Masons. Suppose it was an UTMA for his kids, for example. I'm just wondering whether you see a distinction there. My impression from the cases is that most of them have involved client funds, and I suppose that's just because that's what goes on out there for the most part. Could you comment on that?
There have been other instances where lawyers have stolen from those who were not their clients. They've stolen from family members. I believe one of those cases was the case of Office of Disciplinary Counsel versus Kieswetter, where Mr. Kieswetter stole funds from his sisters and nephews. Mr. Moreman, regardless of whether these were client funds, these were certainly funds entrusted to him. These were not his funds. As a lawyer, you cannot take your hat off as a lawyer and say, I'm not a lawyer at this point in time. Therefore, my theft is less serious than it would be had I stolen client funds.
Counsel, this is Justice Doherty. Following up on Justice Weck's comment, you indicated that this case, Kieswetter, what was the ultimate sanction against that counsel?
Disbarment.
Fair enough.
Mr. Napoli,
Yes,
Justice Todd.
yes.
Mr. Napoli, in your preparation for this argument, have you uncovered any cases in Pennsylvania, any disciplinary cases where felony crimes were committed and there was an adjudication of them, a finding of guilt, and the sanction issued by our court was anything less than disbarment?
I cannot think of one off the top of my head that where the sanction was less than disbarment. I'm sure there probably were criminal cases where the sanction was less than disbarment, but those instances, I think one of them cited, I think in Mr. Moreman's brief, the case of the Assad case. Mr. Assad was convicted not of theft, but he was convicted, I believe, of forgery by obtaining false prescriptions to obtain prescriptions for his own benefit. Mr. Assad was not disbarred because his conduct was found to be personal in nature, primarily.
How is that personal in nature, counsel?
Because
He misappropriated goods from another. I mean, what makes that personal in nature? I mean, are you suggesting he had a mitigation defense, a Braun defense?
Mr. Assad, I believe that he did. I believe Mr. Assad did have such mitigation. He also was, Mr. Moreman cited his case for the purpose of saying that, well, Mr. Assad did not participate in the disciplinary proceedings, but I did. Mr. Assad, however, was found by the disciplinary board to be credible in his assertion that because of his physical mental condition that he was unable to participate in the proceedings. So there was no aggravation in his failure to participate.
One follow-up question. The cases that you cite in your brief all deal with attorneys who stole from estates or things of that nature.
Yes.
What's the citation of the case that you referenced earlier?
Mr. Kieswetter?
Yeah.
It's Office of Disciplinary Counsel versus Kieswetter, but I do not know the exact citation for that case.
How do you spell Kieswetter?
That was my case, so I should be able to spell it. I think it's Kieswetter.
Okay, thank you.
You won the spelling bee. You won the spelling bee.
How would we know if that was right or not?
I'm sure that will be checked on.
Can I ask you just one follow-up question?
Yes.
Mr. Moreman told us today that some of these missing money came from expenses. For example, he talked about being at Sam's Club and charging items for the Masonic Lodge on his Sam's Club account and then reimbursing himself with these checks. Did he ever provide any documentation to support that theory?
I think he provided to the hearing committee certain bills and minutes of the meetings of the Masons Lodge. However, the only person there to authenticate those exhibits was Mr. Moreman. The only person who testified to that was Mr. Moreman. All of this is contrary to his guilty plea, and that should be given no weight. Thank you.
Thank you. We understand the issue and appreciate the advocacy of the board.
And thank you for the privilege of appearing. Thank you.
Take a very brief break, call the next case.
Thank you.
This argument is General Motors Corporation versus the Commonwealth of Pennsylvania. Representing the Commonwealth of Pennsylvania is J. Bart DeLone. Representing General Motors is Mr. Kyle Solly.
Good morning. This is a corporate income tax case which concerns a deduction that permits corporations to carry net losses across years. In Nextel Communications versus Commonwealth, this court found that a $2 million cap imposed by the legislature on net loss carryovers violated the Pennsylvania Constitution's uniformity clause. The present appeal concerns further ramifications of that 2017 decision. Mr. DeLone.
Thank you, sir. Mr. Chief Justice, and may it please the court, my name is Bart DeLone. I'm with the Pennsylvania Attorney General's office, and I'm here on behalf of the Commonwealth. On the issue of prospectivity, to quote the court directly, the decision of this court invalidating a tax statute takes effect as of the date of the decision and is not to be applied retroactively. That is Osgas at 285. That is also the rule, not the exception. Again, quoting, ordinarily a ruling invalidating a tax statute is not applied retroactively. That is Stans Bethworks at 325, and that is the rule that was applied in Nextel. Taxpayer.
Mr. DeLone, I'm sorry to interrupt, but I want to clarify this from the get-go. We're not talking in this case about a taxing statute. We're talking about a deduction statute, aren't we? Do I have that wrong?
Well, yes, Your Honor. I think we are talking about a taxing statute because it comes out of the tax code, and how you calculate the deduction is part of how you determine what tax is payable or not payable. So that is why the general rule of prospectivity is applicable here as it was in Nextel. So yes, this is a taxing statute.
So even though the specific provision we're concerned with in this case, as opposed to Nextel, concerns itself solely with deductions, you're saying that's a distinction without a difference?
Well, Your Honor, Nextel concerned itself with deductions too. It's just that at that point, the court had decided that the way the deductions were formulated violated the uniformity clause, but it's still the same topic. We're still talking about the net loss carryover deduction. We were talking about that in Nextel, and we're talking about that here. So that, and in Nextel, the taxpayer sought retroactive application so he could get a refund, and this court held that there would be no retroactivity either with respect to refunds or assessments. Now, there is an exception to the general rule of prospectivity, that is retroactivity. One of those exceptions has to do with whether or not a decision announces a new principle of law. But Nextel did. It represented a break from what this court had previously decided in Warner Brothers. Retroactivity can also sometimes apply where a decision is not forward-looking, but Nextel was forward-looking. It talked about the tax not being enforceable going forward. Finally, there.
Mr. DeLone, excuse me, it's Justice Baer. You started off by citing Oz, Gas, and another case suggesting that tax statutes are prospective only. You then go to the argument, the Chevron Oil SCOTUS case that has a three-part test for prospectivity or retroactivity. Is there something special that your research has revealed regarding tax statutes that takes them out of Chevron, or is this a case like any other where we apply tests to determine prospectivity and retroactivity?
I think the way I would phrase it, Your Honor, is the way that this court phrased it in Oz Gas at 285, which is to say the reason you have a general rule of prospectivity is because of the potential danger to the public fist in having taxes that are paid, budgeted, and spent. That's why the general rule is prospectivity. And I think the point of the Chevron Oil factors is to determine whether or not prospectivity should not apply, not whether or not it should apply. And as we detail in our briefing, we don't think any of those factors are satisfied here. I've explained why prospectivity is the general rule, but just going to the Chevron factors, there was a new principle of law that was announced in Nextel. And to understand that, you have to understand that we're talking about two different kinds of taxes. One, I think people can easily understand, where you have tax brackets, and depending on how much your tax is worth, you get a different percentage of taxable income. So you're, like, for example, Cope's estate, the threshold was $5,000. That's a tax bracket. At below $5,000, you paid nothing. At above that $5,000 in estate tax, you paid 2%. That is entirely different from what was presented in Nextel, that where the percentage of tax never changed. There was no variation. It was just a question of how you calculated the tax base. And before Nextel, just like in Warner Brothers, the way you calculated the tax base, there was a dollar limitation. In Warner Brothers, the dollar limitation was $2,000. Here, the dollar limitation is $2 million. I guess that's adjusting for inflation. But the point is, you don't have a variability in the percentage tax. You have a difference in the way the tax is calculated. And in Warner Brothers, in 1942, this court was presented with a uniformity challenge to the calculation of the tax base, just like in Nextel. But in Warner Brothers, this court said that did not violate the uniformity clause. And as we pointed out in our briefing, that's a decision that the Commonwealth had for decades, I should say, relied upon from 1942 to the decision in Nextel in 2017. They relied upon it for how they structured the net loss carryover deduction, and they relied upon it in how they structured certain calculations of capital stock tax. So there's no question here that a new principle of law was announced with Nextel, because this court explained, you know what? We got Warner Brothers wrong. We didn't do it correctly, and that analysis with respect to tax bases does implicate uniformity, and you can't do what you've been doing for decades anymore. That is a change in the law, and that satisfies the first Chevron factor. With respect to the second one, frankly, I think that's kind of self-evident. You look to whether or not the decision is forward-looking. Any decision, as this court said in Osgas at 283, any decision that relates to disallowing taxes going forward is forward-looking. That easily satisfies the second Chevron factor.
Counsel, it's Justice Donahue.
Yes,
I thought we decided in Nextel that it was to be applied prospectively only.
You did, Your Honor. That's exactly what.
Okay, so why are we here? I mean, how could that case not apply to the parties in that case, i.e. Nextel, and yet apply to others from earlier years? I mean, why are we reconsidering the prospective only holding of Nextel?
I believe we are, Justice Donahue, because the Commonwealth Court didn't view it the way you and I do.
Oh, I understand that, though, but isn't the answer is the court has ruled on that?
I think, Your Honor, that is very much the answer. As we said in our briefing, we find it a little disconcerting that this court has made this decision a number of times, and then in one of the companion cases to this one, sent it back to the Commonwealth Court and said, please do this in light of the decisions we've already made. Now, in fairness, I think Judge Brobson below, as we pointed out in our briefing, completely understood this court's decision in Nextel, completely understood that what his colleagues were trying to do was contrary in almost every particular to what this court has decided in Nextel. And I'm going through these various factors for the benefit of the court, but I think you've encapsulated it perfectly, Your Honor. And I think my answer to why we are here is because the Commonwealth Court, with all due respect, refused to listen to what this court has already told them in Nextel.
Can I ask you a question? Assume the Commonwealth Court was correct and somehow we got that wrong. The notion that these types of holdings applying to taxing statutes apply prospectively, the best I can tell, I mean, the argument that underlies all of it is what you mentioned earlier. There is an assumption or presumption that having the taxing body repay money that's already spent is somehow not a palatable outcome. The Commonwealth Court held that there was no evidence that there was actually any harm that would result from repaying the taxes. Why are they wrong?
Your Honor, they're wrong because if you look to page 21 of the brief we filed below, we told the Commonwealth Court that if you look to the general obligation bond disclosure forms, you will see the amounts of money that are at stake in these various iterations of allowing the Nextel decision to be applied retroactively. We also made it clear to the Commonwealth Court at in re FB that that's the kind of thing that this court or that court can take judicial notice of. And as we said in our briefing, because you're absolutely right, that's what the Commonwealth Court said. But as we said in our briefing, citing to what we presented to them, we found that perplexing, frankly. We told them specifically what the damage was. We told them where to find it. We gave them authority on why and how they should do it. And they just acted as if we had not done so. And I was perplexed then, and I'm perplexed now.
I have just one other question. One of the amici made an argument that really sort of struck me as something we should think about. If rulings such as Nextel apply prospectively only, aren't we giving the legislature a free shot at enacting unconstitutional statutes, keeping the money that was unconstitutionally garnered, and then moving on because there is no impact as a result of the enactment of an unconstitutional statute?
Well, there's a couple of things there, Your Honor. Frankly, I think that sounds more like a public policy argument than a legal one. And I think this court has gotten...
Isn't it a public policy argument that it's less equitable to have a taxpayer be denied the funds that they paid that were unconstitutional as opposed to putting that burden on the Commonwealth? That's pure public policy.
Well, I guess I'd say it a little bit differently, Your Honor, keeping in mind that the whole point of the McNulty decision, as we said in the briefing, was the reason for prospectivity is that the decision takes effect when the decision is made. So whatever a taxpayer owes or whatever assessment somebody might be entitled to begin and end from that date. So we don't think there's anything necessarily inherently unfair about starting and stopping from when the decision is made. And the intricacies of the equities that we've been talking about is the exact reason why that should be the general rule. I think with respect to what the speculation that amicus is making is, I guess I would say that there's a strong presumption in the law that this court has recognized over and over again that what the General Assembly passes is constitutional. It's obviously up to this court, but I don't think I would assume that they're acting in bad faith. And I do think that the Chevron factors give this court enough leeway to look at individual circumstances and see when the general rule of prospectivity should not apply. We don't think that is this instance at all. I just want to make one final point. I think the court sort of understands where we are, obviously our view is that we should never reach retroactivity, but just to reemphasize, I think what Justice Sonahue was talking about, again, Judge Brobson completely understood what this court had said in Nextel and said that even if you get to retroactivity, which you should never get to, that this court's decision in Nextel, because of your intricate review of the legislative history, absolutely forecloses what General Motors is seeking here, which is an unlimited net loss deduction. The General Assembly already had that choice and specifically said between an unlimited net loss deduction and no deduction, we'll take no deduction. Court said that in Nextel. Brobson understood what this court said, and we think you never should get to retrospectivity, but if you do, you should follow Brobson because he got this court's decision correct.
Although, Mr. DeLone, Justice Berrigan, Justice Brobson thought we erred in putting aside the question of whether Nextel is prospectively only on its face, which is an issue in the case, obviously. Judge Brobson thought we erred in Nextel. He thought as a matter of due process under the McKisson case that the taxpayer who, although maybe factually distinguishable, at least the taxpayer who pays their tax up front and then has to apply for it, as a matter of due process, should get something. That there was a lack of fundamental fairness when Nextel realized no benefit whatsoever from its litigation, even though other taxpayers did. Under the same rationale, is there, as a question of due process, federal due process under SCOTUS law, does General Motors, because they brought this litigation, are they entitled to something?
No, I think, with all due respect, as correct as Judge Brobson was on the impact of this court's decision, he was wrong about that. And one of the things he sort of, again, with all due respect, kind of missed is that McKesson involved a well-established principle of law, and here the law, as we've discussed, changed with this court's decision in Nextel. Also, I should point out that in OzGas at page 281.
Mr. DeLone, can I interrupt you for 1 second?
Sure.
Do me a favor, and just as a hypothetical, assume for a second that we interpret the Nextel case not as new law. You argue there's a change in old precedent, and that's new law, and I respect that. That we look at that and we say that's a tried and true application of the uniformity clause in conformity with 100 years of Pennsylvania cases. So assuming for a second you don't get new law out of Chevron, now does McKisson and due process kick in?
No, it does not kick in. It does not kick in, and here's the reason, Your Honor. New law is only one of the factors, and this court in OzGas took a look at McKesson. Somebody in OzGas pointed McKesson out to the court at page 281 and said that precludes this as a matter of due process, and the court rejected it. And so no, I don't think it does. I think it is. My opponent seems to suggest that new law is sort of the overarching factor. It's not. If you look at OzGas, the three factors in the Chevron test are new principle, but the other two, and they're not, they're separate. It's a totality of the circumstances. Now, let me reemphasize that since we have been using Warner Brothers since 1942 through to 2017, I know that's your hypothetical, Your Honor, but I must respectfully suggest that your hypothetical sort of ignores the last 60, 75 years of what the Commonwealth of Pennsylvania has been doing. But even if you do that, I think, McKesson does not preclude this. And moreover, the other thing that Judge Brobson was getting wrong was McNulty, which is the whole point of prospectivity is it starts from the date of the decision. So there's no refunds, no assessments. When the decision came down in 2017, that's when the decision came down. And the General Assembly listened to this court's change in the law in Nextel and changed the statutes. And frankly, all this discussion of equities and the like is the exact reason, as a matter of public policy, that it should be and has been and must continue to be prospective only. Because if you go rippling back, you're going to have all these different complicated factors where as you go rippling forward, everybody has incentive to challenge tax statutes they don't like. And it was prospective in Nextel. It should be prospective here. And that is why we respectfully request that this court, once again, with all due respect, explain the Commonwealth Court's error and order no further relief for General Motors.
Thanks, Mr. DeLone. But your final point would be too, and I think you kind of made it inferentially, but even if you were to apply Nextel retroactive, the remedy would be to eliminate the net loss deduction for the tax year, right?
That is correct.
You wouldn't sever the whole net loss deduction dollar cap and leave an unlimited deduction.
That's the one thing as this court said in Nextel after a detailed analysis, that's the one thing we know the General Assembly would not choose, because they had that choice in 1991 between an unlimited deduction and none, and they chose none.
Thank you, Counsel for Mr. Sully.
Thank you, Chief Justice, and may it please the court. Kyle Soley for the taxpayer. I want to go, Justice Donahue, to your look at the Nextel case. I want to make sure that we make a distinction between remedy and retroactivity, because I think the two of those sort of blended together in the discussion that this court just had regarding Nextel. There's no doubt that Nextel did not get a remedy. And Nextel had petitioned for a refund, and it didn't get one. But I also think that there's no doubt that this court, in terms of retroactivity as such, applied the uniformity principles retroactively to the 2007 year. And I direct this court's attention to page 766 of the Nextel opinion, where it wrote this: by striking this provision, that is the flat cap, all corporations for the 2007 tax year would be limited to taking a net loss carryover deduction of 12.5% of their taxable income for that year. Now, so this court did look retroactively and saw which law are we going to use to decide the dispute, and remedy, which is how are we going to fix the uniformity problem in the year. And this court in Nextel said we can fix the uniformity problem in the 2007 year by striking the offending flat cap. And if we do that, what's left is this percentage cap. There's no uniformity violation with a percentage cap. Therefore, we have fixed the uniformity problem. But as to Nextel, there's no remedy. So I just want to make the clarification that we don't blend those two concepts. And also so that we don't adopt a rule in the Commonwealth, this, I think, absolute rule of tax prospectivity that the Commonwealth is arguing, because we're blending it together with the remedy. And that gets me to, Mr. DeLone started his argument with that sentence in Oz Gas. And I'd like to—
Solly, can I ask, I don't want to interrupt the flow of your argument, but the notion that decisions of validating a taxing statute are generally and presumptively prospective, that's in line with the federal jurisprudence, right? U.S. Supreme Court, they apply the same principle when they invalidate a tax statute, federal or state.
It is not, Your Honor. In fact,
my understanding, because, unless you can get you don't think they're all prospective, those federal cases?
I would direct you to the case of Harper. Harper now tells us that all federal tax cases are mandatorily retroactive.
Invalidating a statute?
Invalidating a statute.
Is that only when there's no pre-deprivation remedy, no availability of injunctive relief, or a petition for reassessment?
No, Your Honor, because in the case, the unanimous Supreme Court case of Reich versus Collins, the U.S. Supreme Court said that there cannot be a distinction made between pre and post deprivation remedies. In other words, a state can't hold out to a taxpayer and say, you can pay your tax and claim a refund, and then later on say it would be too much of a burden to pay that refund. So in the Wright versus Collins case, the U.S. Supreme Court unanimously said we can't distinguish
What year was that?
post deprivation remedies.
Wright versus Collins.
It's Justice Barrett. That was the rationale behind the due process analysis in the McKisson case. That if you're going to make them taxpayer pay in advance and then seek a refund, it offends due process to say you can't get your refund because it's already been paid. So that, I think, at least I think we understand. But it seems to me to be a tremendous leap to say that because of that scenario, which the U.S. Supreme Court decided under the Commerce Clause and a pre-deprivation's taking, that all tax litigation is retroactive. And frankly, that does surprise me, as it surprises the Chief Justice, because of the twin pillars in this case of protect public fisc and encourage investment. So,
well, Justice Barrett, I wanted to respond to Justice Saylor's question about the test at the federal level, and it is absolutely the case that at the federal level, involving federal law, all decisions are purely retroactive. That there's no concept of prospectivity anymore at the federal level. I believe that there still is at the state level. The taxpayer is not arguing for a blanket rule of pure retroactivity at the state level. All the taxpayer is saying is, let's use our traditional tool of the Chevron oil test, which this court used in McNulty, which the court used in Osgas, which the court used in the auto trade case. Let's use that, because there are instances, this idea that we never go retroactive in a state tax case involving state uniformity is not true. In fact, we always have gone retroactive. Cope's estate was retroactive. The Budd case, which we cited in our briefs, was 10 years retroactive. The Columbia Gas case was retroactive. There was a Gilbert Associates case was retroactive. In fact, there has never been a case at the state level, setting aside Nextel, because I think we disagree with the Commonwealth on whether that's retroactive or not, or whether that's a remedy case. Set Nextel aside. Up until then, there had never been a case where this court found that a statute was non-uniform at the state level and refused to apply that holding retroactively. Not one case. The only cases where this court refused to go retroactive were where it performed a Chevron oil test, like in McNulty, or where there were special procedural or revenue concerns involving localities, like in the casino cases, or both Chevron oil and special revenue concerns for localities, like in Osgas. But when you talk about a state level tax involving the uniformity clause, this court has never decided not to apply that retroactively. It has always applied that retroactively.
may I, again, Justice Fair, again, and just to clarify that, and obviously one of us will pull all these cases out of your brief and that you just said and look at them. But in all of those cases was a test employed. Chevron subsequent to its passage or its decision, and before that, something the equivalent. And in every one of those cases, under the test, we went retroactive, or was there some presumption of retroactivity that changed with Chevron?
So the cases that were decided that I just mentioned after Chevron were the Columbia Gas case and the Gilbert Associates case. Those were decided after Chevron oil. And it was so clearly retroactive that no one even argued the Chevron oil test. Now, we're not saying that the court should adopt a rule that's mandatorily retroactive. That's what's going on at the federal level. On the federal level, everything's mandatorily retroactive, and we're not advocating that rule. We're advocating the rule of Chevron oil, where you look to see if there's a change in law, and then you apply the other factors if there has been a change in law. And and frankly, the reason we advocate for that is that was the rule that this court would use generally for other instances. If you look at Christie versus Cranberry and in other instances where there was a change in law, this court would apply Chevron oil. So we're simply saying, yeah.
Suppose we do that, counsel, and we go retroactive. Doesn't Nextel require us to sever out the whole deduction? I mean, isn't that what we concluded about what the General Assembly wanted? And under that test, you've underpaid. So you're better off.
Yeah, so here's what we say, that, Your Honor, is that this in Nextel, there was two caps. There was the flat cap and the percentage cap. And this court said two things. It said, we're not going to sever the whole NOL deduction because we do want to incentivize investment, accomplish the General Assembly's intent, which was both to encourage investment and to protect the fisc. The problem with this case is we don't have that middle ground. So I would say Nextel didn't answer that dichotomy. The dichotomy in this case wasn't presented in the Nextel.
Just a brief follow-up, Count. I appreciate that. Just a brief follow-up. We do know from Nextel, though, that the General Assembly did not want an unlimited deduction. I mean, you can't deny that, can you?
I can't, but this court also said the General Assembly didn't want to get rid of the deduction altogether. And that's why in our briefs we make so much about the presumption of severability. In other words, where you get to a point where you have two sort of irreconcilable things that the General Assembly is looking to do, and how does the court decide between them? Okay, in Nextel, the court could, because it could accomplish both by the limited severance of the flat cap. But if there's two competing considerations, and this court looked at both of them in Nextel, how does it do that? And we say, well, the presumption is in favor of severability, and in fact, the Tax Act itself contains a severability provision which says you sever the least possible bit to get to a constitutional tax, and that would be the flat cap. Where otherwise this court would be making the sort of the legislative policy choice, and it doesn't have, how does it figure out what the General Assembly would have done?
Mr. Soley, it's Justice Todd. As opposed to, as compared to Nextel, it seems to me that there's no logical way to sever in this case.
Well, but I guess the question too is sever what, right? Sever. I think you can sever. I think you can sever the flat cap because the deduction by itself, if you looked at the Statutory Construction Act, the test would be, is what remains capable of execution? And is it possible to believe that the General Assembly would have enacted the deduction without the cap? And we think the answer is, first of all, we all know that it's possible to apply the deduction without that. That's
not what the General Assembly wanted.
Well, but we don't know whether, if faced with the choice, remember, every state around Pennsylvania allows an uncapped NOL deduction. So is it true that the General Assembly would not want Pennsylvania to be competitive because New Jersey and New York and Maryland and all the surrounding states allow the NOL deduction? Or is it true that Pennsylvania would say, we've got to protect our fisc? And I think the answer comes from the Statutory Construction Act, which is, if you're faced with that situation where the court has to sort of make a decision, the preference is in favor of severability if what's left can be executed. And we can't possibly envision a situation where the General Assembly wouldn't have wanted that. And again, because of the competitive environment, because it's an NOL deduction is uncapped at the federal level and in every surrounding state surrounding Pennsylvania, we don't think it's impossible to believe that the General Assembly could have intended a net operating loss deduction without a cap.
You know, Justice Berrigan, to hear the Commonwealth tell it, erred in Nextel. I'm not sure we did, but it doesn't make any difference. Why doesn't it make sense and not prejudice your client meaningfully to strike the net loss carryover as the remedy if you get by retroactivity, and then let the legislature pass a new net loss carryover that conforms with the uniformity clause and has or doesn't have a cap of 10 million or 2 million or 20 million. You still have your 202,000 of net loss carryover, assuming that the legislative intent that they want to stay competitive with these states around us, and therefore they're going to allow net loss carryover. So you take it in 2023 instead of years 2001.
Well, first of all, I would say this is the bankruptcy estate of GM. So we're not taking any deduction in any future year on account of it. So set that aside. And I think actually that matters a lot for the underlying policy question involving uniformity retroactivity. Estate taxes, real estate transfer taxes, taxes on one-time gain. If this court has this wooden rule of non-retroactivity, there's never a remedy for those kind of those tax types and those taxpayers. It's a big problem. In fact, this court I would direct this court to the auto trade case, right? The auto trade case was interesting. Philadelphia imposes a mercantile license tax for 4 years. The taxpayer claims a refund. Philadelphia repeals the mercantile license case. The Commonwealth Court says, well, the case is moot because the tax has been repealed. Justice Barrett, to your hypothetical, that the thing has been fixed, right? Philadelphia says we just did self-help by repealing this ordinance. This court said that's not good enough. That's not good enough. There was a uniformity problem. You collected taxes 4 years, and you, the city, can't fix that by simply repealing the tax and keeping the money. We have to look and see, and so this court ordered a Chevron oil analysis to see if it was the uniformity was based on new law or not. But this court said, McKesson, due process requires that if a state collected a tax, if the jurisdiction collected a tax, even if it fixes it going forward, that you have to deal with the deprivation of that property contrary to Pennsylvania law. And so all we're saying in this case is that's the standard this court should again apply. Chevron oil, to see whether there's a new principle of law, of uniformity law applied to a past year, and that we have to analysis. In Osgas related to, so there was this case from like 1910 called E.H. Rockwell. And E.H. Rockwell said that mineral interests are real estate for tax purposes. So all the taxing jurisdictions around the Commonwealth for 100 years, in reliance with E.H. Rockwell, were collecting taxes on mineral interests. Then this court in the IOLTA case, it's the Independent Oil and Gas Association case, said, no, that's wrong. But the lower courts had actually affirmed E.H. Rockwell. All the lower courts said, yeah, mineral interests are taxable. This court in IOLTA said, we're going to reverse that. Mineral interests are no longer taxable. And then in Osgas, this court said, IOLTA, because it reversed this test in E.H. Rockwell, was a new statement of law. And in fact, even in IOLTA itself, the lower courts had to be reversed by this court. And so this court in Osgas said, applying Chevron oil, there's a new statement of law, and we're not going to hold those local taxing jurisdictions accountable for having collected tax under a tax law that was that we had held was okay under this old authority. So this court in Osgas, after applying that Chevron oil analysis, said we're going to apply this decision prospectively only. I would say, by the way, Mr. DeLone, when he quotes the Osgas sentence, he leaves out one part of it. He leaves out the beginning. This court doesn't just say a decision invalidating a tax statute is applied retroactively. It says this: we reaffirm McNulty, that a decision of this tax court, so on. McNulty explicitly involved a Chevron oil analysis. McNulty explicitly involved reversed authority. The McNulty case, there was this long line of cases, Arrow Mayflower, that was reversed by the United States Supreme Court, and McNulty said, we're going to apply Chevron oil. We have a change in the law, and for that reason, the case is going to be prospective only. So in Osgas, Justice Weck, when this court wrote what it wrote in Osgas, it premised it with, we're reaffirming McNulty, that is, we're reaffirming the applicability of a Chevron oil test, and then it applies the law prospectively only.
Thank you. Do you have anything else you'd like to add? We're going to try to wrap this up.
That is all, Your Honor. I guess I would again underscore that this court take into account the distinction between remedy in Nextel and retroactivity, because I think if the court makes that distinction about the opinion in Nextel, the court will see Nextel was retroactive and then should apply the principles from there. Thank you very much.
Thank you. We'll take our usual brief break and then call the third case.
The next argument is Commonwealth of Pennsylvania versus Joseph McCabe. Representing Mr. McCabe is Ms. Catherine Ernst. Representing the Commonwealth is Mr. Stanley Joseph Conoval.
Good morning. Appellant, a veteran, was charged with theft by unlawful taking. After pleading guilty, he entered the Veterans Treatment Court, a predisposition program designed to rehabilitate veterans suffering from mental health issues. He successfully completed the program and was then sentenced to 2 years probation in order to pay $34,000 in restitution. The first issue accepted for review is whether Chapter 3 of the Rules of Criminal Procedure, a chapter governing accelerated rehabilitative disposition, also governs the Veterans Treatment Court. The second issue is whether the United States Constitution required the trial court to dismiss appellant's criminal charge once he successfully completed the Veterans Court. The briefs also discuss the potential application of the illegal sentence doctrine. Ms. Ernst.
May it please the court, my name is Catherine Ernst of Wiseman & Schwartz on behalf of Joseph McCabe. At its core, what this case is about is that Mr. McCabe, a veteran disabled by his service in Vietnam and an exemplary participant in the Veterans Court program, paid $1,000 out of his meager disability income toward restitution during the course of the program. He did everything possible to comply with the terms of the program. The question is whether he can be required to do the impossible, and whether if he cannot do the impossible, he should have a criminal record when a man who had money would not. The outcome of this case violated the rules of criminal procedure and the United States Constitution. So I will first address the rules issue, and then I will address the constitutional issue. As to the rules of criminal procedure, regardless of which rules this court deemed to govern Veterans Court, Mr. McCabe's restitution order was not permitted by the rules of procedure or Pennsylvania's restitution statutes. Either Chapter 3 applies, and thus Veterans Court should have taken Mr. McCabe's ability to pay into consideration when setting the award, or Chapter 3 does not apply, in which case there was no authority for the imposition of pre-sentencing restitution at all.
Counsel, I apologize cutting you off in the midst of this, but you raised an interesting issue. Share with us. You indicated that he successfully completed the program, yet part of that program was paying his restitution, which he did not pay. So how do you state he successfully completed the program when an essential element was not completed?
So as a condition of, he signed an application when he entered the Veterans Court program, and the application did mention that there would be restitution that would be part of the program. And Mr. McCabe was in fact ordered to pay $100 a month, which was the most he could possibly pay out of his $700 a month disability checks. And he made that payment every single month as required by the court. There's nothing in the Veterans Court manual that says that there was a requirement that he be ordered to pay an unaffordable amount of restitution, nor that, and nor did he agree when entering the program to the specific amount that was ultimately ordered.
Counsel, the allegation is that your client misappropriated $34,000 worth of gold coins, for which caused him to be brought into the criminal justice system. When I'm failing to understand the concept of the Veterans Court is a diversion program so that criminal convictions may not result. But part of that is rehabilitation and restoring some of the victims back to the rightful property without an admission of guilt at this point. What makes your client so different that he deserves not to pay the restitution for which he agreed and voluntarily submitted that he would on the record?
So under the ARD rules, Mr. McCabe's ability to pay the restitution would have had to be taken into account before the restitution was ordered, before the court, ordered $34,000. But to more specifically answer your question, you're right that the purpose of restitution is to either be rehabilitative or to provide deterrence to the defendant. But the thing is that there's been no allegation by the Commonwealth in this case that Mr. McCabe needed any additional rehabilitation and needed any additional assistance.
Your client's service to the United States as justification for getting away with stealing $34,000 worth of gold coins. That's what you're saying on this record. Is that what you believe?
That is not what I believe. Mr. McCabe engaged in the Veterans Court program. He was considered exemplary by the court. He acted as a role model. Paying restitution was not the only aspect of this program.
But Ms. Ernst, excuse me, it was an important part, and it was understood by him at the very beginning that restitution would be a part of his program. And, you know, the Veterans Treatment Court program is a wonderful program, and it's a voluntary program for individuals such as your client, if they're accepted into it, to avail themselves of all of the opportunities for treatment, rehabilitation, drug treatment, alcohol treatment, whatever it is they need, and they're given that, and that's why this program is so successful. But there is nothing in Chapter 3 of the ARD rules that would apply to a Veterans Court scenario, which would then allow your client to escape his responsibility to pay restitution. And I'm going to listen to your argument, but I don't see anything that would lead me to believe that this vet court program, in his case, was a get out of jail free card, which entitled him to walk away from an obligation of $34,000 of restitution.
And following up with that, but keep just in, let me add to that. You also say that Chapter 3 ARD should be considered by us. That's the first issue. Yet I'm somewhat troubled by the fact, as Justice Todd just indicated, you agreed, or your client agreed, to $100 restitution for the payment of $34,000, which $100 a month, which exceeds the maximum 24 months permitted under Chapter 3 for ARD. So I find it somewhat illogical to request Veterans Court to apply, or Chapter 3 to apply to Veterans Court, when the facts before this court belie the fact that he's violating the rules of ARD.
Well, I first want to address what Justice Todd mentioned, which is that restitution is an important part of the program, and Mr. McCabe took that very seriously, and therefore he made every payment that was ordered of him while he was in the program, and did everything he could. He paid any extra penny that he had toward the restitution. So this is not a thing in which Mr. McCabe feels that he should get out of jail free card. He participated fully in the program. If he would have had the full amount of money to pay, then he would have had his charges dismissed. That's the way the program works. If he had the money, his charges would have been dismissed. And the fact is that there is another avenue for the Commonwealth to ensure that the victim be paid while not giving someone a criminal record exclusively because of their poverty. And that comes under Rule of Criminal Procedure 586, which is court dismissal upon satisfaction or agreement. And under that rule, the Commonwealth is permitted to require, as part of its basis for asking for a null clause, it can ask that the defendant take satisfaction, or if the defendant doesn't have the present ability to make satisfaction, the defendant could sign an agreement saying that he will continue to make payments, and if and when he has even more money come his way, then he would pay the restitution.
Why did he stop paying the $100 a month?
Excuse me?
Why did he stop paying the $100 a month?
He's never stopped paying the $100 a month. He's been continuing to pay the $100 a month. This isn't about whether or not he should have to repay the victim for what was taken. This is about whether he should have a criminal record when someone who had the money to pay at that time did not. I have never argued that he shouldn't have to repay. He absolutely can and will, And he's been making every payment that he possibly can.
But that's not every monthly payment. Every payment that he possibly can. What will the record show us? Has he made consistently? Has he made monthly?
Pays $100 a month. He's to this day. He still pays $100 a month since he left Veterans Court.
I'm curious, Attorney Ernst, where you find the proposition that your client would have, in fact, received a dismissal as opposed to continuing on, from the program. My understanding is there's no promises made to people who enroll in Veterans Court as to the final disposition of their charges.
It is true that there is no fundamental right to ever having your charges dismissed. And the Commonwealth typically can use its discretion. And
more to that, though, the paperwork that your client signed when he entered into the Veterans Program uses the word, the program completion, successful completion of the program may result in charges being dismissed.
That is right. And so, but the Commonwealth has admitted in this case that the sole reason that it did not move to null pros Mr. McCabe's charges was the fact that he did not have the present ability to pay the restitution and therefore did not pay it. And so the thing is that while you may not have an affirmative right in advance to have your charges dismissed, if the Commonwealth acknowledges and admits that it utilized its discretion in a discriminatory manner under the Constitution, then that is wrongful and the conviction should be reversed. And that goes to my second argument, which is that—
Can I just jump in on that? Your
Sure.
client, I thought your client was not ARD eligible, right? He couldn't make the restitution, and they weren't required to move through Veterans Court, were they?
No.
Right?
I'm sorry, you broke up there for a moment. Can you repeat the question?
He was not ARD eligible, right?
I really don't know the answer to that, to be honest. I think that it very well may have gone to Veterans Court because he was a veteran, and that happens sometimes.
Well, he couldn't make restitution, right? He couldn't make restitution at the outset. They didn't put him in ARD, and they weren't required to put him in Veterans Court, were they?
No.
Okay.
May I, counsel? I'm sorry, Justice White, you done?
No, I'm good. Thanks.
Well, and actually, though, I had the same question as Justice Weck, but I want to follow that a little bit. I think, unlike some of my colleagues from what I'm hearing, I may have some empathy for the equal protection argument, that the only reason that this individual doesn't get the benefits of Veterans Court is poverty. But I had the same question. Could the state have looked at your client's scenario, said, yes, he's a fine candidate, prevent him down? Or would you be bringing the same constitutional argument that the only reason he's not in Veterans Court is poverty, and that's deprivation of equal protection?
I'm sorry, you broke up a little bit, but if I understood the question, you were asking, could they have excluded him from Veterans Court in the first instance? Because
without the problem of his constitutional right of equal protection.
If the only reason that they were excluding him from Veterans Court is because he didn't have the ability to pay the restitution, then I would submit that as the same thing as them not giving him the full benefits of the program because he doesn't have the ability to pay. And that's, in fact, what the Superior Court found in Melnick, which, of course, is not binding on this court, but I think it's highly persuasive authority, and it has been cited by highest state courts in other jurisdictions when they've confronted similar circumstances. And the thing that I really want to emphasize, once again, is that because restitution is a statute, is part of the sentence, then in order to order restitution, he had to have been sentenced, which is not the same result that he would have gotten if he had the present ability to pay. Whereas the Commonwealth could have asked Mr. McCabe to make an agreement, a written binding contractual agreement to make these payments to the victim, and then dismiss his charges as they would have anyone else. And the victim would have been in just as good of a position in terms of getting paid, but Mr. McCabe would not be treated differently from other people.
Ms. Jones, let me stop you because you're a little far afield of what I was asking.
Okay.
Here's what's bothersome. And your answer, I think, is logically consistent. If there's an equal protection argument and your client prevails at this juncture, that he's been deprived of equal protection or substantive due process by having a criminal record because he couldn't make restitution. And then you follow that, as you just told me you would, and said, if they don't let him in to Veterans Court, or it could be alcohol court or any mental health court or whatever specialty courts we have, solely because he can't make restitution, that's equally a deprivation of equal protection. We've taken equal protection from sort of a defensive mechanism to an offensive use. Every veteran, regardless of the amount of restitution owed, and every other specialty court person can force their way into the program and can thereby eliminate their obligation to pay restitution under the Equal Protection Clause. Isn't that the next logical position from where you are?
The Commonwealth has extremely broad discretion in terms of deciding whom to admit to these programs. And that is not up for debate in this matter, and nor am I arguing that they should not have wide discretion. However, if they admit in their briefings, as they did here, that the sole basis for the action that they took was because someone doesn't have the ability to pay, then that shows that their discretion was being used to discriminate on an improper basis under
Just to follow up, doesn't that I mean, on one level of abstraction, I understand what you're saying, but doesn't that ignore his consent to the Veterans Treatment Court conditions? I mean, that's not a non-existent or meaningless fact. Doesn't the fact that this man, with the relevant colloquies, et cetera, and forms, consented to the conditions of this program, which is a matter of grace, I think we can agree, doesn't that abrogate these other issues that you're now complaining of?
Well, as I said, when he entered the program, it said that he would pay, that part of the program would involve the payment of fines, costs, and restitution. The costs in this matter were waived by the court because he didn't have the ability to pay. And as to the restitution, it didn't specify full restitution. It didn't specify if you cannot pay before the end of the program, then you get a sentence, whereas if you could have paid, you do not. And as I said, I see no problem whatsoever in the rules or for equity, certainly, that Mr. McCabe could be made to agree to make payment. And he has no objection to that. He's been making payment to this day.
We understand that we're getting repetitive now. I certainly understand your arguments.
Well, Chief, if I may ask one question more in a procedural posture.
Yeah.
Counsel, let's get back to the original Alcott question, the application of Chapter 3 of criminal procedural rules to a veterans court. As the establishment clause for problem-solving courts, which is heard in Section 916, it clearly indicates that there are no rules and the individual judicial district may adopt local rules for its administrative application of the process. Excluded from the Establishment Clause is any reference to Chapter 3 of the Criminal Procedure Rule. I'm interested in finding your argument as how you believe Chapter 3 is applicable when the Establishment Clause for all problem-solving courts excludes it. Secondarily to that, your second issue as to raising or the ability to pay, to me, somewhat troublesome outside of Justice Baer's concern about equal protection, which I kind of disagree with Justice Baer on the concept because this is a voluntary program. The question that I have is, in pursuit of ARD or in lieu of Veterans Court, he had to enter a plea of guilt for which restitution would have been entered. And his ability to pay would not have been at issue until the Commonwealth moved for enforcement or incarceration, which is the triggering point for the court to consider one's ability to pay. As we know, the criminal statute's written so that restitution is to be applied as is at time of sentencing. It's only in our enforcement that the true ability to pay. Now, all judges do that. Will take into consideration the ability to pay at sentencing. But the question comes back to twofold. Share with me where the Establishment Clause permits the introduction or the adoption of Chapter 3, and why, with it being excluded, do you enjoy the benefit of paying the restitution, yet restitution under the current status of his conviction permits him to continue indefinite, just continue probation until he's able to make his payment and or now face an ability to pay hearing. Does that make sense to you, or do you need me to repeat that?
I'll do my best. So it is true that Section 916 doesn't explicitly reference ARD, but nor does it reference any other section. It simply generally references the rules of criminal procedure. And since this is a pre-disposition supervision program, and ARD are the only rules in the rules of criminal procedure that provide for pre-disposition supervision, it leads one to believe that that is the section that they were referencing. But if it's not the case, if instead what the legislature had in mind was that localities would create wholly unique rules, then localities would need to adopt local rules pursuant to the Rules of Judicial Administration, which was not done here. There was nothing ever published in the Pennsylvania Bulletin, and this court can certainly take judicial notice of that provided for any of the procedures that happened here. And it's really important that these rules be carefully considered, as the ARD rules were carefully considered by this court when they were adopted decades ago, because it can result in something such as this. The Commonwealth in this case is arguing that the Veterans Court Manual, that was not properly adopted as a local rule, authorizes 1106 restitution to be imposed pre-sentencing, but the Veterans Court Manual doesn't say that at all. It just references restitution, and as we know, there are multiple kinds of restitution, some for which ability to pay needs to be considered, some for which it is not. And so without having that clearly specified, Mr. McCabe knew restitution was going to be part of the program. Mr. McCabe knew he was going to have to make payments, but he didn't know he wasn't going to get the full benefits of the program because of his poverty occasioned by his disability.
Counsel, it's Justice Donahue. Just for the sake of helping me understand this, let's take the treatment court out of this. Let's say that your client just pled guilty. Okay, just pled guilty, because he did plead guilty here, correct?
He did.
It was a guilty plea. Okay, so once a guilty plea is entered, the trial court is in a position where it is going to apply 1106. Is that not correct?
If it gets to sentencing, yes.
Okay. Why isn't that what happens here? I mean, you were talking about this as though your client is not getting a benefit out of treatment court, but he is. He's not facing any prison time. I mean, and which makes total sense in conjunction with his voluntary guilty plea, his agreement to go into the treatment program, and at the end of the day, he agreed to pay restitution. So I'm not sold on the application of Chapter 3 to this. And so if I look at this purely in the context of an individual who voluntarily pleads guilty and is later sentenced, and it's the trial court, not the district attorney, who is at the end of the day deciding the terms of the restitution, it's the trial court. As I read the trial court's short discussion of this issue, she did in fact take into account the nature of the crime that was at issue here. So, I mean, I'm having a hard time, accepting your proposition that the ARD applies, and secondly, if it doesn't apply, isn't this precisely what should have happened in this case? An 1106 restitution sentence would have been imposed.
So every participant in the Veterans Court program prior to Mr. McCabe who participated and successfully completed the program had their charges dismissed. Mr. McCabe, when entering that plea, which was a requirement to enter the program, had that had that in his contemplation when he entered the program. And so, yes, it is a voluntary program, but you also have to think about what the participants were expecting and what the outcome would be. And to say that if he is sentenced, then 1106 restitution would be applied begs the question of whether he would be sentenced. And it was his understanding that if he successfully completed this program, that he never would be sentenced and his charges would be dismissed.
But he was never promised that. I mean, when he entered this program, he understood that there was the possibility that even upon successful completion, he would have to do what he agreed to do, which is pay restitution. I mean, and if I'm struggling with the voluntary nature of this. I mean, he didn't have to do this at all. I mean, he could have been tried and then just sentenced, and there likely would have been prison time involved and likely 1106 restitution. So, I mean, it appears to me, and I don't see anything in this record to suggest otherwise, that he benefited mightily from the Veterans Treatment Court program in terms of helping him get through a difficult time and things of that nature. So I'm just, and the argument that everyone else got it, it's individualized. I don't know what the trial court considered at the end of the day when he or she was, deciding the ultimate disposition.
Well, and many crimes, Ms. Ernst, don't involve restitution, but plenty do. And throughout our Commonwealth, the counties that offer Veterans Treatment Court programs routinely award or order restitution when it is part of the case, but it's not always part of a case.
Ms. McCabe, Justice Barrett, I think we've beaten this horse, but you just referenced everybody else who went through the program. It's infers that you're aware of those cases. Did any of them have restitution due at the conclusion of the program?
Not that I'm aware of. And I just wanted to say to Justice Donohue's point that if the Commonwealth would have used its discretion to say we don't want to dismiss Mr. McCabe's charges because we believe he needs additional rehabilitation, because we believe he needs additional deterrence, or for any justifiable reason, that would be acceptable. But the Commonwealth has admitted in this case that the only reason that it did not null pros Mr. McCabe's charges is because of his inability to pay. And the court, in its opinion, only references his failure to pay restitution when justifying her sentence, and does not in any way say that the court didn't want to dismiss the charges because of the seriousness of the crime. The Commonwealth misused its discretion in an unconstitutional manner, and I think that is what needs to be focused on, not the fact that this is a discretionary program or a voluntary program, which is absolutely accurate, Your Honor.
And the trial court could have said, nah, he went through the program and I'm going to not order restitution. It was ultimately the trial court's decision in this case, was it not?
It was, and the trial court cannot discriminate against Mr. McCabe based on poverty any more than the Commonwealth can. And since Mr. McCabe had completed all aspects of the program other than the pay money he did not have the ability to pay, his charges should have been dismissed.
Thank you. We'll hear from the Commonwealth.
May it please the court, Stanley Joseph Conable, Assistant District Attorney for Montgomery County on behalf of the Commonwealth. The Superior Court correctly concluded that veterans courts are not governed by the ARD rules of criminal procedure. ARD originated in the 70s, decades earlier than the first veterans court, not just in the Commonwealth, but the nation. ARD is a pretrial diversionary program, whereas veterans courts in Montgomery County and several other jurisdictions are diversionary programs that require a guilty plea up front. The legislature has previously required county courts to create ARD programs, and it specifically used the term accelerated rehabilitative disposition. In the statute authorizing the creation of problem-solving courts, the legislature omitted that label, which shows that not all problem-solving courts are ARD programs. The rules of criminal procedure likewise prescribe ARD procedures without stating that they govern other diversionary programs or problem-solving courts. As for defendant specifically, he pleaded guilty. He agreed to pay restitution, and then he completed the program and he received a probationary sentence. There were no due process or equal protection violations here, because
Mr. Carnival, Justice Baer, I think you just put, at least to me, the heart of at least the equity here. This defendant went through a 2-year veterans court process. He got nothing whatsoever of benefit out of that, unless it's the esoteric benefit of being a better citizen. You admitted him, not you personally, Montgomery County admitted him to the Veterans Court, put him through 2 years of supervision, and then at the end gave him a criminal sentence that he'll live for with the rest of his life, a criminal, and to collect the restitution. But meanwhile, he's got probation, he's got a criminal conviction. What good did Veterans Court do him? Isn't at least the pragmatic mistake that you should have never let him in?
No, Your Honor, because the Commonwealth, at the guilty plea hearing, advised him that the standard range of the guideline sentence, the standard range of the guidelines, was a state sentence. The mitigated in the guidelines was 6 months. So the fact that he received probation at all is a benefit. Moreover, his participation in the program also, in his case, if you look at the guilty plea transcript, it noted that he suffered from PTSD and other mental health issues for which he was receiving treatment. And enrolling in the program provided him the incentive to continue with that treatment and the structure to complete his therapy, for example. And that's one of the things that's noted in much of the secondary literature cited in the Commonwealth's brief, is that veteran courts exist because existing behavioral health courts or drug courts or even ARD, they don't necessarily provide veterans with what they need.
Mr. Conovo, I have to just chime in here to disagree with the premise that my esteemed colleague, Justice Baer, set forth, that there may be an esoteric benefit, but that may be it. I mean, you're talking about a 2-year Veterans Court program, and Veterans Court has the word treatment in it for a reason. It's a Veterans Treatment Court. They don't sign up and get accepted, and then a year and a half or 2 years later, the judge says, okay, good job. You've been around for a year and a half, 2 years. We're going to say you completed the program. That's not it at all. They come into court every week or every 2 weeks. They are subject to treatment through the VA. They get drug and alcohol counseling. They have a myriad of benefits that are provided to them to get them back on the road to life, to a normal life, and back on the road to good health, good mental health, and employment stability. So it really is much more than just saying, okay, I graduated from Veterans Court. They get a mentoring aspect that no other specialty court provides, and it truly is a gift. It's by grace that they get into this program and they receive the benefits. So I'm not sure if Montgomery County offers all of those things I've talked about, but I know it's one of our model Veterans Court treatment programs.
Hey, counsel, I have a question, almost as a follow-up to what...
Let's answer my question a minute first.
Oh, I apologize. I didn't know you had a question. I thought
I know it was more than a question, but it did end with a question.
I'm sorry, Your Honor.
The question was, Montgomery County is one of our model Veterans Court treatment programs. I understand that it does have many of the components I've described, if not all of them.
Yes, Your Honor. And the Veterans Court Manual actually outlines the procedure here. And defendant's attorney, the trial court, representatives from the DA's office, the VA, they all get together and they come up with an individualized treatment plan. So there is a consideration on a case-by-case basis of what is specifically ailing this particular defendant and how that person can get treatment. So the whole point of the program is to identify what's at the root of the criminal conduct at issue and treating that or facilitating the treatment of that. And then, at sentencing, that's all taken into account.
Thank you.
Yes, Your Honor.
So if I may follow up, I'm somewhat concerned with regard to the procedural framework established by Montgomery County. For example, the Establishment Clause, 42 Purtons 916, specifically indicates that it's for the treatment. They are admitted to a court-supervised individual treatment program. Yet, what you currently have in play is not a treatment court program. You have the facade of a problem-solving court for a deferred adjudication of a criminal conviction. Once you require the defendant to enter the plea of guilt, it is no longer a diversionary program per se, because it's no longer a treatment program. It's introduction into the criminal justice system. So, as counsel has indicated, why should Chapter 3 not apply when your office itself circumvented the framework of the problem-solving treatment court and made it a clear entry of a guilty plea?
Well, Your Honor, firstly, several Veterans Court programs across the nation require guilty pleas up front with deferred sentencing and the possibility of a dismissal that's deferred until completion of the program. So this being a Veterans Court having this, requiring this guilty plea up front, it's not uncommon by any means. And nowhere in the statute does it say that an individualized treatment program can't require a guilty plea up front. Like there's nothing prohibiting that, basically. And if you look at the ARD rules, those are completely distinct. So they're basically, a pretrial diversionary program is not the same as a diversionary program specifically. So the Commonwealth's position is that you can have these, pretrial or pre-indictment diversionary programs such as ARD, but that's not to the exclusion of other diversionary programs, which can require a guilty plea up front. There are no rules of criminal procedure. There are no statutes. There's nothing prohibiting this from occurring this way. And in fact, at this point, it's up to the several counties' discretion to decide how they best administer the program and what they find to be most effective. So,
Noble, may I ask a question, please? This manual, which is the only guidance the defendant gets there in Montgomery County, I guess, has a sense upon completing the program, and this is the expectation, participants may have the court consider dismissing or reducing their charges. Is that correct?
Yes, Your Honor.
So you have some expectancy that if you do everything they ask you to do, having been accepted in the program at the end of the program, the court might consider dismissing or reducing your charges, right?
Yes, Your Honor. What
was Mr. McCabe charged with?
He was originally charged with receiving stolen property and theft by unlawful taking.
And what did he, at the end, so what would you, if he'd have been able to pay restitution, you couldn't reduce the charges, could you? But you could dismiss them, is that it?
But Your Honor,
in other words, you can reduce aggravated assault to simple assault, but theft is theft is theft. So it looks to me like he figured if, I do everything they tell me to do, I have a chance that I'll get these charges dismissed and won't have a record. Is that correct?
Well, Your Honor, his subjective expectations about the program are respectfully immaterial because the program specifically says you may get them dismissed.
Well, I understand that. I read the sentence. It's discretionary. But somebody goes into this, they're saying, look, I've got a shot at getting the charges dismissed if I complete the program.
And he did have a shot, Your Honor.
Well, but let's follow the syllogism. But part of the thing is, going into this thing, he stole $35,000. So he says, you got to pay restitution, right? Well, there's no way this man could pay $35,000, $34,000. So he knows that, you know that. He's a veteran living on $700 a month. So it seems to me that it's almost illusory to accept him into the program and then say you can't get the charges dismissed because you didn't pay something you never could have paid.
Well, Your Honor, I think that we need to look to the trial court's stated rationale for imposing the 2-year probationary sentence and refusing to dismiss the charges. If you look at the transcript of the sentencing hearing, the trial court says you were a model participant in the program, you did everything we asked of you. This was a serious crime, and I find that you need 2 years of probation. So while you have some discussion from the Commonwealth about the severity of the amount of restitution, et cetera, if you look to what the trial court actually said, the trial court did not say, you didn't pay your restitution, so 2 years probation. That's just not what the trial court gave as an explanation for the sentence or its refusal to dismiss. It said,
Donahue, in other words, probation's better than 6 months in jail. Start with that. I got that part. But I'm just trying to get the concept of this program and the expectancy of somebody that goes in, and couple that with the fact, at the beginning, if he gets through the 2 years, he's not going to get the charges dismissed because he could never pay 30.
Well, Your Honor.
So that he knows that. Anybody that takes the program knows. So what are his shots? You can't get the charges dismissed or reduced under your theory.
Well, I think that would be a case-by-case basis.
Make it that pleasant, but this says they may consider dismissing or reducing their charges. But that could never happen under your theory.
I do think that the trial court had the discretion here to say, you completed the program. I understand that you were hard up and gave some kind of other explanation and said, charges dismissed. I think that the trial court had that discretion and it could have exercised that, even notwithstanding the restitution issue.
Mr. Carnival, it's Justice Todd.
They could have said, we're going to dismiss the charges. You've been a model guy. Okay, but you got to sign an agreement. You got to continue paying this restitution. And that's what we're going to leave you with. Charges are dismissed. You have a binding obligation for whatever it's worth or not worth to keep paying $100 a month. And I think that's the point of counsel for the appellant.
Well, Your Honor, that very hypothetical shows that the trial court sentence was not about the restitution. If it could have used an alternate means of getting the restitution, or if it had given some clear indication that the sentence was because of the restitution, then we would know that there was a link to the 2 years based on the restitution, but that's just not present here.
Mr. Carnival, it's Justice Todd. Is there anything in the record, the trial court record, that would indicate to us the disposition of the $35,000, the gold coins valued at $35,000 that were stolen by this defendant?
Your Honor, as far as where they...
What happened to the coins or the money?
Oh, Your Honor, I actually do not know. So what we know is that he took the coins and the victim never saw them again. So we have no idea where they were.
There's no telling where the money went. Let me ask you a question, counsel, on the statute question. There's that pesky 1106, and you were kind enough to send in a post-submission communication with this court's Cochran decision. Although, by the way, you omitted to send in my dissent there. Even under the majority's creative interpretation of 1106 there, the court elasticized the statute to allow 2-month hiatus, like a summer break for the York County DA's office. But there was just 2 months, and the defendant, as the majority pointed out, requested the delay. Here, we have 8 or 9 months, right? And 8 or 9 months. And there's no circumstance involving the defendant asking for that bifurcation. So if Cochran elasticized 1106, would this case break the rubber band?
No, Your Honor. And the reason for that is in Cochran, the restitution order came after the other parts of the sentence, if I recall correctly, whereas in this case, the restitution order came before. So that's an interesting point of distinction there, is that even under the Superior Court's precedent for why we want the restitution to happen at sentencing, in this case, we satisfied those policy preferences. There was certainty as far as what the amount of restitution was going to be. He could contest it, which he did several times. So firstly, it actually arguably benefited him that the restitution order came earlier. It was the first part of the sentence rather than a second part that came later. So that would be the first point of distinction. But secondarily, the defendant consented to it. And he signed the paperwork. There was a guilty plea hearing. He knew there was going to be a restitution hearing. He knew that he was deferring sentencing for his opportunity to complete the entire program. So it's not just about the restitution order itself. He deferred sentencing so he could actually complete the requirements of the program and get a
Yeah, but counsel, Justice Berrigan, and we've probably beaten this to death, but again, in furtherance of Justice Webb, to Justice Todd, etc. A plea bargain is a contract between the defendant and the state, both obligated to fulfill their obligations they're under. We've held that in prior cases. So you tell me, what did he get out of the guilty plea in real terms, when in the end he gets a sentence, he gets restitution? Didn't he waste his 2 years? I understand that he got remedial benefits of it, but from his pragmatic viewpoint, or a typical criminal defendant pragmatic viewpoint, did he get anything out of the Veterans Court at all?
So that would be in addition to ensuring his completion of therapy for his PTSD and other mental health
In
issues.
theory, he could have gone to his local mental health facilities, and he could have gone to the Veterans Administration. I'm not sure Parents Patriae says that isn't it good, pat him on the head, we did all of this for him. It seems to me that if I'm advising a client and we're going to Veterans Court, we don't, maybe I don't know criminal law, but I don't expect at the end of it that it's as if it never existed. I got a sentencing hearing, I got a sentence. What did I get out of Veterans Court?
Well, Your Honor, according to the guidelines we submitted to the court, he was facing a state sentence. So
that's what he got.
and under the case law, the standard range of the guidelines is presumptively where a defendant should be. So I have no reason to believe that absent some kind of mitigation, like completion of the Veterans Court program, for example, the Commonwealth would have been on board with even probation.
I understand your answer. I think you'd said it before, so I don't mean to be impatient at all, but we're almost done. I'm just curious, is this a regular occurrence where veterans want to enter the Montgomery County Veterans Treatment Court? The DA lets them in, they go through it, and then they end up with a state sentence, or they end up with a sentence at the end of it, as opposed to an old process.
Your Honor, I can't actually give you an answer to that question. All I can tell you is how we do it by the book, which is that ultimately it's up to the judge. So these cases, a case-by-case basis, and if you look at the manual, the Commonwealth cannot just keep somebody out of Veterans Court. You know, if there's a conflict about whether someone should be subject to a condition or whether they've completed that condition or what the sentence should be, it goes to the judge. So ultimately, that's who makes the decision. So it's not like the Commonwealth has some kind of unfettered discretion to keep people out or to, tell the court what the sentence should be or something like that. I mean, by the book, it's the judge who makes the decision whenever there's a conflict.
Thank you very much.
Thank you. Thanks to both counsel. We're going to take a 45-minute recess, and then we'll call the next case.
Thank you.